Hello and welcome to the BYU Library Family History webinar. We're glad you could join us today. I'm Olivia Tueller and I'll be your host for this webinar. If you have technical difficulties during the webinar, please use the chat box and I can address your concerns. You are welcome to use the chat box during the webinar for comments, insights, and questions. However, all questions will be addressed at the end of the presentation. Our next webinar is on October 13th with Jeremy Minty. He will be giving a presentation entitled Personal Digital Archiving. If you would like to access a previous webinar, please visit our webinar index on our website or search in our YouTube channel. All of our webinars are recorded and uploaded by the following Monday for your convenience. We also post links to recordings and other updates on our Facebook and Twitter accounts. For today's webinar, we are pleased to hear from James Tanner, who will be giving a presentation on copyright law for genealogists, an update. Before we begin, here's a little bit about James. James has over 40 years experience in genealogical research and is an avid blogger of Genealogy Star blog. He has served as a family history volunteer for 18 years and has presented at expos and conferences around the US, Canada, and Europe. He is a member of the board of directors of the Family History Guide Association and is currently serving at the BYU Family History Library. James is a professional photographer and has 7 children, 34 grandchildren, and 2 great-grandchildren. And if James is ready, we'll turn the time over to him.
Okay, well, I'd like to welcome you all here to another webinar from the BYU Family History Library, and we're glad to be here. We're going to talk today about copyright law, sort of with a slant towards genealogists, but it applies pretty broadly across all people who are involved in doing research or publishing or writing or whatever it is that where you have to be concerned about whether what you're using or what you're copying has to do with the copyright laws in the United States and elsewhere. We're going to talk about copyright law in the United States. Many other copyright laws are similar to our copyright law here in the United States, but every single one of them is different. And if you are concerned about the copyright issues, and it turns out that you're looking at another country, there are some commonalities. And one of the first places, and I'll mention before we even get started, is called the Berne Convention. It's B-E-R-N-E, like in Bern, Switzerland. And the Berne Convention has signatories, including the United States, and they all have a common basis for their copyright law. There's only a few countries of the world that are outside of the Berne Convention. So if you wanted to look up and see some other country, that's where we would start. Before I get into discussing anything specific, I have to give kind of a disclaimer, and that's that although I was a licensed attorney in the state of Arizona with experience in intellectual property law, I am now retired and not licensed to practice law in any state. Anything I say should not be construed to be a legal opinion on any particular case or controversy. If you need legal assistance, I recommend that you obtain the services of a licensed attorney who can practice in the United States federal courts. Okay, so that kind of explains the situation. That doesn't diminish my background and my knowledge of the subject. It is merely the fact that I am long since retired and always need to advise people before I start talking about legal issues of that particular problem or that challenge. Okay, this is copyright.gov. That's a very simple address for the US Copyright Office. And basically there's 3 things they have on here. One is they have all the copyright laws. 2, they have an extensive explanation of copyright. And 3, they are the ones processing copyright registrations. And if you are not familiar with the copyright.gov office, you'll probably soon learn that it is part of the Library of Congress. So technically it's part of the Library of Congress, but it has it's a separate government entity. So copyright in the United States starts with the United States Constitution, Article 1, Section 8, And basically, to promote the Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. One of the things you find out very quickly as you begin to look at copyright law is the fact that it is totally vague. Every single case that's decided changes the law slightly. And we'll talk a little bit more of that as we go along. But one of the things that's in the United States Constitution is that it secures this right to authors and inventors to the exclusive rights for just a limited times. It says limited times. Well, the time limits now are, as I'll probably repeat, extremely extensive. And as I'll get into, we're probably never going to outlast the time it takes for a copyright today to expire. So we'll just kind of start with that as an explanation. One thing that's really important to understand about copyright, assuming you are claiming a copyright to some type of document or production, something, one of your works, one of the things that you want to keep other people from copying, and without using you or paying you a royalty or whatever else that you would think would go along with doing having a copyright. And that is that constitutional right of copyrights is reserved to actions in the federal courts. So you can't run down to your local justice of the peace or to your state court in whatever state you're at and start a copyright action. They do not have jurisdiction. That means they cannot hear cases that are based on this intellectual property, part of intellectual property called copyright actions. Now, what does that really mean in practicality? It means that copyright litigation is for the big companies, the big guys out there, people who have limited resources very rarely are able to get involved in a copyright conflict, other than being the defendants of somebody suing them for infringing on their copyright. And the practicalities of it is the expense of taking a case to the federal district court under original jurisdiction, or being the only court you can use, means that you have to find attorneys who operate in the federal district court, and I can assure you that they get paid for their work. So this is something that we need to be aware of right out the bat, that if I've got this and somebody's violated my copyright and I'm going to go to court, I'm going to sue that person. Well, the answer is, let's get through that right at the beginning and go back to what I just said about the cost and the expense and the time that it takes to pursue a case in the federal courts. That's not to mean that there aren't a lot of copyright cases. There are a substantial number of copyright cases every year. It's just that the people who are involved in those are generally people who have the funds, the wherewithal to pursue a case in the federal district courts. Public domain. Now, the first thing that we talk about with copyright is what isn't copyright protected. That's pretty straightforward and in the United States. And so we can not have any concerns about it if we kind of focus on the time frame of what we're talking about here. Although the current copyright law has been extended to an excessively long period of time, in excess of 75 years. So it's like 75 years plus the life of the death, from the death of the date of the author or the publication, whichever was first. So basically, you can end up having well over 100 years or more of copyright protection today. That's not always been the case, and there are a substantial number of works out there that are no longer covered by copyright. And so when we talk about work being in the public domain, I'll get into some more details about that as I go along. But we need to be aware that there are things out there that are freely copyable. And it doesn't have, there's no restrictions and there's no concern at all about the fact that somebody's going to come back and sue you because you've copied or used this particular item. That's called the public domain. And here's the rule. On January 1st, 2019, for the first time since 1998, by the way, expired copyright works entered the public domain. So this was it was actually stopped at 1923 for these years since 1998. And now the Congress did not renew the extension of the Sonny Bono copy. Yes, that's the Sonny Bono, that's the movie star or entertainer, whatever, Copyright Act. He ended up being a senator and was the one behind this particular bill. And it was effective in 1998 and extended copyright for 20 years. And that could have been extended by the United States Congress, but it was not. And so beginning in 2019, every January 1st, another year's worth of copyright goes into the public domain. The original Copyright Act that was passed, the extension that was passed by Congress in 1998, was called the Mickey Mouse Law because it was passed by pressure by Disney Industries to extend the copyright on Mickey Mouse. And they basically liked the idea, and so it went through the Congress and was extended. It's not to say that Mickey Mouse is now completely out of copyright. It's because it's only the parts of them that extend back before 1926. So it'll be a long time before we get to having some of the other Disney things that are no longer under copyright. But the interesting thing for most of us is that a lot of books, publications, and movies are slowly moving their way into the realm of not being copyrighted. And I'll have some more to say about that public domain as we go along. So works prepared by an officer or employee of the United States government as part of that person's official duties are in the public domain. Now, the reason I'm reading these so that you hear it and see it, because it's important. And the wording that I use here is wording that is, let's call it legally defensible wording. It's the kind of wording that attorneys use. So what does that mean? It means that if the government publishes it, unless they specifically reserve their rights or tell you it's restricted in some way, it's freely usable. And this opens up a vast number of documents and records and publications. And it's important to understand that it's not just government, it's the federal government, the United States government, that has this restriction. In other words, when they produce things, they're free to the country. And that is always helpful to me as I do research, because I can use images, I can use information from the Library of Congress or the National Archives or from any of the government agencies maps or anything else that might have been produced by the United States government. And I don't have to worry too much about whether or not it's copy protected, but it's always helpful to do some checking on every one of the documents or images or whatever that you use. The unfortunate thing is that the works that are produced, the websites and the images and things may contain copyrighted material. They can also be created under a contract that preserves the author's copyright claim. And also state works can be covered by the copyright because they're not part of the federal government. So the state can either opt in or opt out. And so to make life more interesting for people who are in the publication business, you have to check all 50 of the states and the territories in order to see if the document that you are trying to use or want to use has been covered in that way. So here's how I work as I do webinars, as I do the images that are produced for these webinars and for my classes and all of the other videos and publications online and the blogs and things like that, is that I always systematically, without even now thinking too much about it, I will not even touch anything that looks like it may be copyrighted. I only will handle items that I can visually verify that they are no longer subject to a copyright claim. And so that limits me in some sense, because I spend quite a bit more time finding the visuals for my classes and for my webinars than I do anything else. When I'm doing a movie, for example, a video for the library, and I have to look at every single one of the images I use to make sure that there isn't some kind of an arguable or justiciable, which means could go to court, claim by someone to a copyright. Sometimes it's not clear, but there are exceptions. And one of the major exceptions is for works used for educational purposes. And there's a thing called fair use, the fair use doctrine. And fair use, you may have heard of that term being used and thrown around. But unfortunately, fair use is not part of the federal law. Fair use is a court derived or instituted type of right that says that under some certain circumstances, certain people in certain circumstances with regard to copyright are not violating the Copyright Act as it is. So it's kind of a negative thing. If you get sued, it's a defense. You can claim I had fair use of the material because of these factors. And that has become extraordinarily complicated under the rule of the internet, with all of the material that's on the internet, all the flood of images and information and all these different things. It's virtually impossible in some circumstances to determine whether a particular item is copyright protected. And all I can say from my own personal way of using the material is that if I have any doubt that it could be copyrighted, I won't use it. And it's only when they're specifically say this work is free to be copied or free to be used, or basically have put it in a situation where everyone would assume that, then I can use it. Now, what about, for instance, right behind this pop-up message is a copy of the Library of Congress's website. Well, that's kind of a really sort of vague area, but this being in a federal government, there's no problem because I can take a picture of it. But what about other websites? What if I do screenshots of a genealogy website when I'm putting on some kind of a presentation? So what would that entail? The answer is fair use. Everything I'm doing is for educational purposes. And as long as I don't use a substantial portion of the document or whatever it is, the website, if I reproduce the whole of anything, I'm in trouble. If I copy an entire book that's copyright protected, if I copy an entire website or entire substantial portions of a website, all of those things would create a claim for copyright. But if I use under the fair use and the kind of educational exception, then there are very, very good arguments. Nobody's going to come down and try to assert that kind of claim on when they have put things on the internet in a very visual way without marking clearly that they are going to claim that copyright, even though it isn't required by law, as I'll talk about in just a minute, to make that notice. So basically, copyright law changes with every single federal court decision. And the only way you can keep current on what is and what is not subject to copyright would be to review every single court decision. And in the areas that I worked in while I was practicing law actively, if the questions came up, then I would have to review every federal court decision that had been made for a period of years. And in one case that I took, I had to go clear back to the federal court decisions in the 1860s when copyright laws were really began to be enforced and put forth in the United States. And it's a long process, and it's something that's you can imagine now why it would be very, very costly to get into litigation in a federal district court over the fact that what this court said was agreed with this court. Maybe they don't agree. Maybe this is another. It always creates more confusion. And so from the standpoint of a publisher, people who are publishing information, as I am constantly, it's really kind of like this mangrove swamp that's out there. You cannot imagine how hard it is to really understand. And since I consistently err on the side of safety as avoiding any kind of claim, that's what creates sometimes a time factor for me. It takes me longer to find the images for my presentations than it does to either do the entire script or present them or anything else. That's just the most time-consuming part, is avoiding this issue of copyright. Okay, so I'm not going to go through these individually. I just want you to look at this and see the time frame of the copyright laws that have passed and how the different parts of copyright were added over the years. So if you're wondering about whether or not sculptures or paintings or musical compositions are part of copyright, yes, everything now is subject to copyright. Now, in 1909, there was a distinction between pre-publication and post-publication. And publication is also another legal term. It doesn't mean you necessarily published it through a publisher and made some money off of it. It means if you make it open to the public, and then it becomes a published thing. If it goes on the internet, you can consider it to be published. But if it's pre-publication, if you have never put it online, no one's ever looked at it, it's your private journal or it's your history that you're writing or whatever, then you have copyright protection, and there's no question that can be. And as we'll see, pre-publication rights are more extensive than post-publication rights, meaning before something is made public. If it's the old one that you find a diary of your great-grandfather in a trunk, and the question comes up, can you publish this? Does somebody own the copyright? Is it available? The answer is there are specific rules and laws that are part of the copyright law that talk about the rights of according to a document pre-publication, and the time periods are involved are rather more extensive than the rest of the copyright law. And then in 1976, they abandoned that distinction. And the reason why that happened was because the copyright law in the United States changed substantially, and there is no difference. Now, this is the fundamental issue that happens in the United States. And I'll get to that in just a second because it's important. Here's where it's codified. This is the actual law, the books that are involved. First of all, it's the laws are all the federal regulations and laws are contained in two publications. One of them is the United States Code. It's called USC for copyrights. And it also has everything else from A to Z, every other federal law. So if you're to go online right now, you can get a digital copy of the updated present United States Code. All I can tell you is when it was published on books, and these books in the background are called the U.S. Code Annotated, or USCA, and they are I don't remember how many volumes it was up to, but it took about a whole wall of our conference room in my law firm. So there's just this one set of documents. And back then, before we had the internet, before we had all the laws digitized online, accessible, we actually had to have the books. It was interesting because when I moved from one law firm, from being basically a sole practitioner, in fact, I had retired from the law in the sense that I was no longer actively pursuing clients because I was running computer businesses. I was part of an Apple dealership. I owned an Apple dealership, Apple computer dealership, and a software development company. I was a partner in a software development company. And so we were also very concerned about copyright laws in both of those areas. But there's on top of the code, there's also federal regulations. And there's another huge set of books called the CFR, which is the Code of Federal Regulations. And they contain the details of how the copyright law or any other law is going to be implemented. In addition to that, you have the treaties and laws that have been passed by the legislature, which are, by the way, are all in the United States Code eventually. But these are the particular ones. The Copyright Act of 1976 was very instrumental in changing the direction of copyright law in the United States. When we adopted the Berne Convention by the United States, we were one of the last countries in the world. The Berne Convention actually was originally signed by the European countries back in the 1800s, in 1896, if I can remember that. Probably not the right date, but it's about that time period. And then there was the Sonny Bono Copyright Term Extension Act of 1998 and the Digital Millennium Copyright Act of 1998, which took into account all of the digital works out there and incorporated the digital works as in copyrightable digital works. The Berne Convention did something dramatic to the U.S. copyright law. Before that time, it was imperative that you gave notice of your claim of copyright. And that's why we have these little symbols everywhere, and where it says copyright date, copyright, and then it says something else, usually all rights preserved. The all rights preserved covers the other countries of the world who don't specifically require a US copyright. But after that time, after the Berne Convention was signed, you basically don't have to do anything to copyright a document. Documents are copyrighted, or works, we'll call them works, which is the copyright term. Works are copyrighted when they become published, in the sense when they become legible, readable in a physical form, even a digital physical form. So anything that's created digitally or on paper or otherwise, recordings, movies, whatever it is, all immediately are copyright protected the second they are created, from the day of creation. So we don't have to give notices anymore. If you go to my website, I don't have this, all stuff is all copyrighted. But if you read on my add-ins, you'll find out that yes, it's all copyrighted because it's all under the Berne Convention. And so it's not something that you need to be put on notice of every single time I put out a document. Now, if you need a quick reference for all of the different ways that copyright can be is in effect presently, Cornell University Library has put out this copyright guide. It used to be about 2 or 3 pages long, and it was really helpful. And now it's really long because the law has gotten more and more and more complicated. But basically, it gives you the definitions of most of the copyright and gives you the terms on all of the terms of copyright and everything else. And you can just find it by putting that up, copyright at Cornell, online and doing a search, and you'll find this document, and it's updated every year to reflect those items that have come out of copyright into the public domain. So this is the central one part, and it's a very great service that they've done to summarize all of the vast amount of copyright law that's out there. So this is kind of what I was trying to say earlier, and now I'm going to slip into some legal jargon, because this is just strictly a legal statement that when an idea is expressed, so you can't copyright an idea, and you certainly can't copyright anything that hasn't been expressed, meaning made in some form that communicates it. And when it's expressed in a fixed medium, meaning rather than a speech. Now, the question is, could you copyright your speech, everyday speech? No, because it has to be in a fixed medium. If you give a speech like this, if I do a webinar today, it's now being put in a fixed medium because it's being broadcast on the internet eventually. So eventually this will be, it's being recorded. The recording makes it a fixed medium, thereby it becomes copyright protected. And it doesn't matter what it is, or whether it's a poem on the back of a napkin. That's the kind of the common image that is used to express the broad reach of copyright law now. So there's a legal protection for a set period of time. It depends. There's more complication than that, because it depends on the type of fixed medium and the type of information that's being claimed to be copyrighted. And there's no copyright formality. There's nothing that's required. No registration, no notice, and it's no longer the case. In the past, they required a formality, but that's no longer the case. So there's no more formal requirements. Now, let's go back to the court. Let's say you were going to the federal district court to file a copyright claim. The prerequisite for you filing that claim would be to have your copyrighted document or work, whether it's a painting, a story, a dance, or whatever it is, have it registered with the Copyright Office at copyright.gov. So you would have to go through the whole process of registration as a prerequisite to going to court. And so that's another aspect of why it could be rather expensive to start claiming copyright and actually wanting to litigate that. So most of us, like I kind of began to allude to, most of us will not live long enough to see current works free from copyright restrictions. The time periods are 75 years plus the life of the author. So if you had an author, suppose you had an author that was in their early 20s or teen or whatever, the copyright protection for that individual, assuming they lived to be an average, say they've lived to be 80 years old, would be well over almost 200 years from now. And that makes copyright nothing like it was originally designed to be by the US Constitution, because basically the issue of it being extended for a period of time it's limited, technically it's limited, but the purpose of the whole Constitution was that at some point in time, the works would no longer be copyright protected. And today that has been put off so far in the future that we couldn't guarantee that it would ever come out of copyright. Here's an important thing for genealogists and others to focus on, and is that facts cannot be copyrighted. So if you're stating facts like the ocean is so many miles wide, or it's so many miles to such and such a place, it can't be copyrighted. And so what happens is that you get into really gray areas. One of the questions that comes up very frequently is, are recipes copyrighted? Well, the way you write the recipe, the doctrine, whatever you want to call it, the commentary on the recipe, that can be copyrighted. But the recipe itself is a fact. It's just ingredients and amounts. And so traditionally, the idea that how you prepare it may be copyright protected, but the recipe itself is not. So it creates sort of this gray, some parts are copyrighted, some aren't. And I would start, and the other problem with even with something like a recipe, which is very easy to understand, is you could vary the ingredients and then you're not doing the same thing. So it's just a very kind of slippery area. But the creative selection, coordination, arrangement of information and materials from a database or compilation can be protected. By the way, understanding that indexes cannot be copyrighted in the United States unless they're put in some kind of format that, but if you just copied the data out of the index, it would never be copyrighted. But in England, it's copyrighted. England went in and said specifically that indexes were copyrighted. So you've got to understand there are some major differences between various countries. So the question comes up in the genealogical standpoint is here we have a bunch of family group records. To what extent are the family group sheets copyright protected? Well, to the extent that they are different from each other or unique, they can be copyrighted. But this is a case where even if you have a copyright notice on your document, that document has got to be shown to have some kind of there's the idea here is that it needs to have a creative portion. It has to be something that you brought to the table. And the answer about family group records is no chance. You're asking for exactly the same information that everybody else is. The means that you put it around, put it in slightly different format does not change the fact that what you're doing is simply providing information, which is not copyright protected. So, and clearly anything that was written on these sheets would not be copyright protected because they're basically facts and historical facts, names, dates, places, etc. So those are the kinds of things that as attorneys, we have to think through and understand, but are pretty hard to take sometimes. Is any portion of the work we do as genealogists covered by copyright? Yes, yes, yes. And the answer is a portion of a work can be copyrighted and other portions may not be. Only the parts of the work that is original with you will be subject to your claim of copyright. So let's say you go in and you write up a whole bunch of information that you got out of someone else's old published book or out of governmental records or wherever you gathered this information across the world from different sources, we'll call it as your sources. Now, can you claim copyright to any of that? That would be, especially if it's all mixed up together, that would be immensely difficult to claim. And subsequently, as I was reviewing copyright law for many years, I would constantly look to see if there were any new cases about genealogy and copyright laws, and there have been maybe less than a dozen total that had even used the word copyright. Excuse me, even used the word genealogy in terms of copyright. Okay, so it's, there's kind of, we don't work in the imaginary world. Everything we're reporting are basically either historical things that were clearly in the public domain or copyright. Now, there's something else about that you should be thinking of when you start thinking about dead people, because that's what we do with genealogy is we're researching about people who've passed away. Now, dead people don't have any privacy rights, and subsequently unless they have willed it and it's been inherited by someone, they probably don't have any copyright rights. When you see a book that's been republished, for example, if many times genealogy books get republished and they're put out by a new company, you can go back through and find out where the original work came from and if they've disclosed that. And it's possible that it's not copyrighted. So it gets into a little kind of a different thing. And so now we're going to get into some interesting parts. On FamilySearch.org, we have over 500,000 digital books that have been scanned. Some of those books are in the public domain. Of the books that are in the Family Search library and Family Search, on the FamilySearch.org website, the digital books, they determine which books are copyright protected. Now, they may be right, they might be wrong, but unless there's a clear lack of copyright that's been determined by the Family Search records will not, they won't let you view it outside of the library and a physical copy of the material. So there may be 500,000 books on the Family Search books area, but a fairly substantial percentage of them are copyright protected and not subject to copyright. Okay, this is another one. Now, the Internet Archive has currently about has 35 million books, essentially publications and books, and in its collection. This makes the Internet Archive the largest accessible library in the world. And one thing about the Internet Archive that's important when you get to copyright law is that they are also a library. And as a library, they can lend books. So they have kind of circumvented the whole problem of copyright by making almost all of their $35 million books into that are available directly by anyone online for free. So this is an important thing for researchers and everyone who's involved with publications to understand, is that you can go to the Internet Archive, which is archive.org, and you can basically view almost any book that's been published, even if they're under copyright. And you may only be able to look at them for an hour, and you'd have to renew every hour, or they can be checked out for 2 weeks, or they're freely copyable and you could download the whole book. And I have found this over the last few years, as they reach sort of a critical mass, that I can find an amazingly high percentage of the items that I want to look at in the Internet Archive. And they're adding in the neighborhood of hundreds of thousands of books every year. And I brought this slide up because you can actually donate if you have a whole big, say you have like me and you have this, thousands of books down on your shelves, down in your basement or someplace in your house. You can donate the whole entire collection to the Internet Archive for a donation to a nonprofit. You can also, they will then take those books, and any that they don't already have copied, then they can copy those and put them online. And because they have a physical copy of the book, they can then make the books available. So this is online for free. So this is kind of like some of the other book things, but this is the large, largest thing that's out there on the internet. So what else is we've got going here? There's another part where you can carve out, if you're not willing, if you really don't want to have anything to do with copyright, and you just as soon share everything universally, there's a way to do that without having to lose your total control. And that is through the Creative Commons license. And so for about the last 20 years now, this is a way, and if you've never heard of the Creative Commons, you need to get into it. And that explains to you what it means by there's different levels, anything from just simple free to restricted to copyrighted, actual copyright. But this gives you every step in between. So you can put publications online and say, as long as you give me attribution, if you say this is my document, then you're free to copy it. And so sometimes in my presentations, when I really need something, I will put the attribution right there on the slide. So there's no question that I attributed the author or creator of that work. So how do you get around this? Well, you get around this by focusing more on the public domain and doing research and finding those websites that have put their collections of documents, images, movies, whatever it is, into the public domain. And by getting people to release their documents into the public domain. Now, that doesn't mean that they're not going to charge you for it. So there's some differences here. There are huge collections out there of images, for example, and many of those images are clearly in the public domain. They were created well before 1926, and yet the people who have them are claiming a copyright and selling them out to the public. This is where we have some real friction between what people do when they have the copyright laws and how they make money off of it, even though it's mostly people don't understand that the document, their picture, photo, whatever you just paid $2 for, or $5 or $100 or $200 or whatever, it really wasn't ever owned by the people who were selling it. So you just have to be a little bit careful out there. All of these websites may say that they are free. And it's absolutely important that you understand the difference between what is in the public domain and what's free and what's royalty free. Okay, all those terms are used. And if you think free and royalty free mean it's in the public domain, you're wrong. Free doesn't mean free. Free means that if you follow whatever you have to do, register, pay an annual fee or whatever it is, that the documents are free. So free is basically not always free. So free is not always free. So be really careful and make sure that the documents either fall within the exceptions of the copyright law, and you're willing to defend that, or are clearly not covered by the copyright law, rather than getting into the situation of whether it may not. Or you can pay for the rights. And when someone waives their royalty rights, that means they don't want to get money off of it. So you're basically not worried about copyright at that point. But you may have to come back and show that you actually obtained a subscription or obtained the record through this particular organization. So a responsible researcher always gives attribution. Now, attribution has nothing to do with copyright. Attribution has to be with responsibility and being open to the public about where your information came from. And I would suggest that that's when we call sources in genealogy, when we say we want to have the sources for everything you put in. Every event in your ancestor's life should have a source, even if it's all the same source, but it's really have to have a source for everything. And that's part of this attribution thing. It's okay in most cases to copy a portion of a work, like give a quote from a website or give a quote of a book or whatever, even if it's copyrighted. But attribution helps when you do that you're not trying to circumvent their claim to a copyright, because you're attributing the work to the person who created it. Okay, that covers it. And I'd be sorry about all the excitement going around here, but do we have any questions? I wanted to leave a little bit more time than usual for questions if somebody had any.
It looks like we have a question from Doreen in the chat.
Okay. If I find a portrait on Google and post it on my ancestor's profile, is this considered a violation or is considered public domain? Okay. Now, when you say a portrait, you mean like a picture of someone that's one of your ancestors or whatever, or a photograph, or I guess I'm not saying, but let me just explain whether it's a photograph or a painting or a drawing or whatever. It's still, yeah, okay, pictures and paintings. Yes, they're covered in copyright, but it's still an issue as whether or not when it was actually made. Now, from my standpoint, if I find paintings online, and I use them from time to time, basically then that paintings become, I look to see who painted it and the origin of the painting. If I can't determine the origin of the painting or its time, whoever painted it, I just don't use it. And if I can verify that the person, lived and produced it before 1926, then I don't worry about it. But that's always a concern. And I spend a lot of time just looking through stuff. Can we use newspaper articles, yearbook pictures? How about headstone pictures? Okay, now let's start at the end of that one. Headstone pictures on Find a Grave. Technically, the person who took the photograph could claim a copyright for their photograph. I have never seen a viable claim for that. I would not use the photograph without their permission, but on the other hand, I think it's a bogus claim because the headstone itself is not copyrightable. Well, it could be. It caught some of the distinctive headstones and the epitaphs and the stuff on them is actually falls under the copyright law. But to find for someone who just went into a cemetery and started taking pictures of the headstones, I don't think that's a creative enough content to be copyright protected. But if they've put down that they're claiming a copyright, I would not use the photograph. Can we use the newspaper articles, yearbook pictures? Same problem. You're back to the same issue. A yearbook picture, for example, was published generally to the public. And it would be very unusual that you would find copyright material in a yearbook. And so it gets into some other issues that also deal with copyright. As for example, if I go out on the street or in a public gathering and I take a picture and it has 10 people in it, can those people sue me for privacy? Well, the answer is they're in a public place. They have no expectation of privacy. And when you're doing a yearbook picture and you get your yearbook picture taken, you have absolutely no claim that you were not expecting it to be published and made public. So it's pretty hard to claim a copyright claim on a picture in a yearbook. And I don't think that would be happening. Can we use newspaper articles? That is really a question because they are published. Obviously, if they're before 1926, the information or the article, there's no problem. Newspaper articles are copyright protected. If you copied the whole article, you would have a problem. If you put the whole article, a picture of the article onto a place like, say, Family Search Memories or something like that, or on one of the other websites, I've never seen anything claims about that. It's clearly there. If they're don't fall under the restriction of the Copyright Act, then it's probable. But usually we're looking, genealogists are usually looking far back. 1926 is like a hop, skip in the back. It's nothing too much. I mean, I have rarely done research for many, many years until just when I were very getting started for anybody who would appear in the 1950 or 1940 censuses. Even if they were there, I was just putting the census or the other records in there just to document their lives. It's not any information that I would really be concerned about preserving. Obituaries, yes, clearly copyrighted. No question about it. They're probably copied more than you can imagine. And that's one way that people can lose their copyright. It's through excessive copying. They allow it to be published online And the expectation is that people will copy it. And so you can't expect that you have copyright protection. That's where one of the biggest arguments go along, and it's usually through people who are involved in the entertainment industry. How does it relate to other countries in relation to genealogy? Well, for example, if you're going to start to copy things from Europe and other countries, you need to be aware that sometimes they do claim copyright. It's interesting, they have in Europe, they have like what's called, in England, they have the royal copyright. And the royalty for things that they have published have a perpetual copyright. And one of the perpetual copyrights is to the Bible, printed by the Oxford Press, which is the official British Bible. And yes, it's copyrighted by the England government, and anybody who reproduces it has to have and sells it has to have a license from the government in England. That's why there's a lot of different translations of the Bible. That's one of the basic reasons, by the way. If I buy a marriage record from the Scottish National Archives, can I post the image on Family Search? It says copyright at the top. Family Search will usually not let you put obviously copyrighted material online. The information, you could put all the information from it online, but not the actual document itself. That's why when you get involved with things like what goes on in England, Scotland, and Wales, and Ireland to some extent, is that they are much more restrictive on the way that they allow their information to be used. So if you want to see what the restrictions are, you can read, for instance, in England, you can go to the British Archives and to the British Library and other places to see what kind of restrictions there are. And you have to pay for all those original documents from England too, and Scotland and Wales. Okay, anything else out there? Okay, well, thanks everyone for watching. If you do have questions, by the way, you can get on the BYU Family History Library virtual help desk on BYU. Just look up BYU Family History Library in the upper right-hand corner. Click on the virtual desk, and you can ask all these questions. And they can either give them to me or get us connected for an appointment or whatever. And I'd be glad to talk to everyone. Okay, anything else? Thanks.
Perfect. Thank you so much, James. We'll go ahead and close.
We hope you will join us for our next webinar, which is on October 13th with Jeremy Minty. He will be giving a presentation entitled Personal Digital Archiving. A recording of this webinar will be made available next week. You can view that on our YouTube channel or on our website. If you have any comments or questions, you can always email us at fhl_webinars@byu.edu or follow Facebook and Twitter. Thank you and have a wonderful week.